Welcome, everyone. I am John Miller, and I am the senior attorney and owner of Rock Solid Law and Title in Ponte Vedra Beach, Florida. We practice law in three areas, representing entrepreneurial small business owners, closing real property, homes, commercial properties, we like to say professionally and on time, and helping families preserve their legacies and wealth through estate planning. Today, we're going to be spending most of our time on the estate planning side of the conversation. And of course, as estate planning attorneys, we also provide probate services. We prefer to keep people out of probate, but we don't get to plan with everyone. So for those that miss their opportunity, we'll help them through the court system. We are going to talk a little bit about probate avoidance this morning because trusts are one of the best ways to do that. As we're kicking off, and for anybody watching on the replay, you probably know more about this at whatever time in the future you're listening to this, but the huge new bill has passed in the United States Congress. Everybody's trying to figure out what it's going to mean. I don't have a legal opinion yet, but it appears to me that it is really going to be beneficial for the very wealthy, and the changes are also going to be very impactful for the lowest socioeconomic groups. For the rest of us in the middle, I'm not really sure how it's going to all pan out, and we'll just have to wait and see. I did hear a presentation yesterday from a staff member of a congressman who voted in favor of the bill. And he provided a number of bullet points regarding how their office feels that this change will be beneficial for small business owners. We will be getting out a bullet point flyer on the points that were made in the near future. So if you haven't signed up for our newsletter, just send an email to questions, and that has an S on the end of it, plural, questions at rocksolidlaw.com. That is also the place that you can send any inquiry that you have that you don't wish to make public on this presentation this morning, and we'll do our best to answer it for you. If you have a question during this morning's presentation, got to get my glasses on for this and see if it'll come up. The chat board is right about there, my big finger in the middle of the screen. If you will click that and type your question in there, I hope that I will leave enough time at the end of the half hour in order to be able to take those questions. If not, again, questions at Rock Solid Law, and we'll try to get that answered for you. Anything else you want to write to me or my team can also go to that email address, and they will get it to me. So the one point, since we're talking estate planning this morning, of course, during the last, number of years, I would say 7, 8 years, we've been faced with the sunsetting of the large estate and gift tax allowance that came in at that time. That has been taken away by the new bill. So it will continue to mean that for each individual, the first $15 million in the estate will not be taxed. Obviously, that is a large number of people, and therefore the extremely high-end tax planning will now only be for a very few number of people. However, there are still great reasons to get your estate plan in place so that you preserve your legacy, and what you want to pass on goes to who you want to get it and when you want to get it. That leads me into today's subject. We're going to be talking about trusts today. There are some basic Trust 101 webinars on our website. If you need to go back and get a little history, I'm going to give you a 1-minute version here. But essentially establishing a trust and transferring your property into it is the subject matter we're talking about. And really, a living or revocable trust is the foundation point for most of the estate planning clients that we see. People ask, well, when is it appropriate? How much do I need to own? We start thinking about it really at about $300,000 in assets, and at $500,000, it makes a ton of sense. And I typically recommend it for those of you that have estate values, real property, savings, investments, maybe you own a business, anything with values over that. We really need to start thinking about how to put a trust, one or more trusts in place that will positively affect your estate, the people you love, your legacy, and pass things on in an orderly manner. So for our discussion today, it's easy to read revocable versus irrevocable trusts. It's hard to say, because if I were to say a revocable or irrevocable quickly, they sound the same. Both pronunciations are correct. So I use revocable for a revocable trust and irrevocable for an irrevocable trust. Neither pronunciation is incorrect, but that way you will know what I'm talking about when I say it. So a revocable trust, also sometimes known as a living trust, or if you want Latin in your legal representation, we can call it an inter vivos trust, right? Which means living in Latin. So I had a law school classmate who's a brilliant writer that says lawyers like to sprinkle Latin throughout our verses like so much salt and pepper on a meal. So I try to stay away from that. I want to talk in a way that, well, hey, a third grader could understand it, but just using common language that everybody can understand. So if I should get too deep in the weeds, too technical, stop me and ask me a question so that I can correct that. So a revocable or living, or sometimes inter vivos trust is a trust into which your assets are placed and over which you maintain complete control. I'm fond of saying that it's as if you took $1 from your left pocket and put it in your right pocket. It's still completely accessible to you. So you put it in the trust so all the assets are in one place. What do you want to do that for? Doesn't it complicate your life? Well, once you have the assets retitled, or funded is the technical term for that, retitled into the trust, no, it really doesn't make your life any more complicated. And what happens is, at the time you pass on, you have named a successor trustee. Now, typically for married people or people in committed relationships, that's your spouse or life partner, and then an alternate, typically somebody that you really trust who's in the next generation. And those people, after you are no longer able to control your assets, immediately step into your shoes. They become immediately in control over all of those assets. What's important about that? No probate lawsuit. Every last will and testament that is not associated with the trust is going to court. It's going to be in a probate lawsuit. Why do I care about that? The reason you care about that are several. One, for the people you love the most, there is no immediate access to your assets. In fact, there's no access to them until a judge says so, which will be no less than 6 months and maybe years, especially if somebody fights. Another reason you don't want to tee up your family in a probate lawsuit is they are already in the venue where they can fight each other. Okay, so we want to keep people from fighting after you're gone. One of the best ways to get them to fight is go ahead and throw them in the ring, the courthouse, so that they can take out whatever whatever dislikes they have against each other. He always liked you best, whatever, from childhood in the courtroom. Believe me, I've seen it. So there is an extreme emotional price tag to going to court. In addition to being not able to access whatever it was you've left behind. So During this period of time, somebody's got to pay for the fees to go to court. Somebody's got to pay for the lawyer, and they don't get paid back until the judge says so at the end. In addition, as I said, it's where fights break out, and that will directly affect your legacy. Can't tell you how many times somebody said to me something that they really disagreed with that somebody in their family did in the probate process. And who do they think of? They think of the person that died. They think of dad when his brother does something awful. They think of dad who's passed away when one of their siblings does something awful. And that will become part of the decedent's legacy, unfortunately. We avoid that by creating trust. So expense, delay, access. And the other thing is, coming out of a court proceeding, whoever you say gets whatever you want, gets it. If they're 18, they get it when they're 18, and statistics are going to show that it's gone by the time they're 19 and a half, okay? So if you really want to set your future generations up for success, you write rules within a trust document that distributes or phases those gifts over time, and you can also restrict how they can be used. So you could, for instance, restrict your trustee from giving gifts to somebody who has an unfortunate, say, alcoholism or addiction to drugs, legal or illegal. The trustee can provide them with rehabilitation, but refuse to enable them by giving the gifts outright. So you can write those kind of rules inside of a trust that you just can't do without a trust. So what does a revocable trust do? It gets what you want to leave behind to who you want, when you want, without the intervention of the court or really any other government official, because as you know, judges are either elected or appointed by politicians. And you get all of it to them without having to pay lawyers, accountants, business valuators. You know, it goes on and on. Realtors, if there's real property that has to be sold. So a great part of an estate can be lost to outside people if you don't plan for it. And the simplest way to plan is a revocable trust. Why doesn't everybody do them? Most everybody I know should. Probably, I don't know what percentage, but the lowest socioeconomic part of the population doesn't really need them, right? And when people don't, we tell them so, right? There are ways of planning around probate for people that don't have enough money and really need a trust. So the revocable trust appoints someone to take over when you can't do it anymore. You could still be alive, but you know, our bodies are living longer and our brains are wearing out. And when people get dementia, they need somebody to step in and take over. That somebody can be appointed by a power of attorney, but it's much simpler to just have them be the successor trustee and take the assets and use them in favor of you, the person, the grantor, the settlor that set up that trust. So it allows you to maintain complete control over your assets and avoid going to court. What it doesn't give you is any asset protection. And people will ask me often, well, now that I have my living trust set up, am I protected from creditors? No, you're not. The other thing is there's not a lot of tax planning in that type of a trust either. So as you get to people that have more and more assets and therefore need to further do planning to try to avoid or only pay the taxes that they're legally required to pay rather than any voluntary taxes, then you may want to consider some other strategies, which we do. And, you know, the Supreme Court of the United States has said that no man, or it was an older case, so no person is required to pay any more taxes than absolutely legally required. And there's nothing wrong with setting up your estate so that you minimize the taxes you pay both during your lifetime and after your death. That is an absolutely legitimate goal, to pay the amount only that you are absolutely required by the government and no more. We like to say there are two tax codes, one for the informed and one for the uninformed. And candidly, the uninformed always pay higher taxes. All right, so I talked about successor trustees, and I talked about these safeguards being in place in case, Alzheimer's or any of the other mental diseases that are so prevalent in our society today, and talked about uh, probate avoidance. Now, just for your thinking, at the death of the surviving spouse, if there is a couple doing the trust, that trust becomes irrevocable, which means that there is asset protection for your heirs after you're gone, but there's none for you during your lifetime. Why wouldn't everybody do an irrevocable trust, John? Because to do an irrevocable trust, you have to relinquish ownership and control of the assets that go into that trust. No, it doesn't have to be, and almost never is, everything, because you need something to live on, right? So when you have the ability to isolate some assets from your estate, that's typically when an irrevocable trust comes into play, because the grantor, the person who puts the money or assets into the trust, loses direct authority to make changes and also loses the control over the assets. So it is really important that someone is appointed who you have great faith and confidence in to follow the rules that you have put in that trust in order to be able to feel comfortable that the assets will be used in the future. And I'll give you an example in a minute, the way you want them used. Because part of gaining the asset protection is that you are going to lose the direct authority to make changes to your trust. Okay. So it's really important. The planning process of doing that trust is really important. And candidly, more important than the actual drafted document itself in the process. The drafted document, of course, is very important. The planning that goes into it is where the real magic happens. So, should you choose to have an irrevocable trust, you'll put a certain number of assets in that trust and name a trustee, and then make the rules of how the trust will be governed. Therefore, you, the grantor, the person establishing the trust, doesn't any longer individually own the trust assets, and the assets are no longer susceptible to legal claims. So the things you put in the trust are put at an arm's length from legal creditors. Are there some limitations on that? Yes, if you attempt to defraud the government to not pay taxes that are legally due, they're going to be able to pierce the trust and get through to it. But that is really getting into a fraud, deception, bad faith area. And I am just trusting that none of you are planning for that result. So those assets, much less susceptible to legal claims. It can result in, if properly planned, in reduced, as I said, tax liability, and also in a lower reportable income annually. So we're talking about income tax, we're talking about estate tax, which is federal. Of course, I'm a Florida lawyer, and for those of you that are in Florida, we don't have a state, a Florida estate tax, estate tax. So, and it can, for people who are qualified, keep them eligible for certain government programs, right? There are, for instance, set aside programs for contracts for certain individuals, often maybe, let's say, veterans or members of a certain minority group. And those can have income limitations on them. So if you are personally receiving all the income from your assets, and you're about to lose your ability to have that work that you do, well, then you can carve out a portion for an irrevocable trust and remove that from your estate, just as an example. Both types of trust will bypass probate court. Important point. It is one of the primary benefits of a revocable trust when you're not interested in asset protection. And also available with an irrevocable trust. And my notes here indicate that's a huge benefit for grieving families, right? The last thing people want to do after you're gone is have to deal with a difficult administration, either through probate or of a trust of your estate. So if you've set out the rules well and you've appointed the fiduciaries well, then you have made it easy. You hit the easy button for your heirs. So one of the purposes of asset protection, like an irrevocable trust, because there are other types of asset protection that are outside of today's discussion, is that they give you negotiating leverage against future creditors who will know that it would be difficult to collect against you because you only have limited assets in your individual name. And by the way, this is outside my scope today, but Florida Homestead is an excellent asset protection device. So we do not need to put Homestead into an irrevocable trust, and almost never do. Let's see. I'm just trying to skim some notes because I see I've got at least one question, and as usual, I've talked through most of the time. So if you put a significant portion of your assets into an irrevocable trust, retaining only your homestead and protected retirement account assets, qualified retirement funds are also asset protected, it'd be difficult for a judgment creditor to come after you. What can a trust do? It can help you navigate specific tax concerns or creditor protection, ensure your wealth supports your family, or leave a legacy for a charitable cause you believe in. I love that part of this practice, leaving gifts to charities for after people are gone. So, downside of irrevocable. I want one. What's the downside of an irrevocable trust? The assets move out of your state. The trust must pay its own income tax and files a separate return, and gives you the protection to the creditors. Now, as part of those trusts, we can set up a trust protector. Often that's the lawyer who drafted the trust or someone else, a professional that you have great faith and confidence in, who can make certain changes to the trust over time. All right. Let's see. There are a variety of irrevocable trusts. I mean, huge amount. Sometimes there's the flavor of the day. You're going to see people pitching them through seminars and things like that. And then there are the standard ones that have been around for years and years and years. So, but the choice of the trust is really up to your individual circumstance or situation, and it can only really be chosen after you sit and consult with us or another professional in this area, an attorney who practices in this area, to learn your particular circumstances and make a determination of what is appropriate for you. So in thinking of getting together and talking, called a consultation, what are your goals? The biggest homework in advance of a meeting is to think what your goals are, because I want to talk to you about what your values and goals are and help you get to the result you need, much more than I want to talk about the nuts and bolts of the documents we're going to use to get there. So what are you thinking about? Are you thinking about transferring wealth to the next generation? Maybe keeping a family business in the family? I mentioned it before, leaving a legacy to the charity you support, minimize estate taxes for you or your beneficiaries, maybe your kids or other heirs, or shielding assets from creditors. Vastly different goals lead to vastly different strategies, right? So we'll talk about those. I'm going to give you a quick result, and I'm going to jump down to, I see there are a couple things in the question. So again, if you have something you want me to address, please type it in here at the chat bar, and I'm going to go there in just a moment. But let me just tell you about one example of an irrevocable trust. It's called an irrevocable life insurance trust, or often referred to as ILIT. Estate planning lawyers love acronyms. CUPERTS, GRATS, not going to talk about those today. GST, generation skipping tax, all sorts of things we like to talk about. But an ILIT is an irrevocable life insurance trust. So obviously there's a life insurance policy, and it's used to fund this type of trust. And it may be put in there to pay estate taxes, right? So you buy a life insurance policy, and that money will be available to pay any taxes that you have to pay after you're gone, so that it's not a burden on those you leave behind being taken out of the corpus of your estate. So it can be particularly useful if you own a family business that's set to remain in your estate when you pass away. You can create it ahead of time to ensure the business stays in the family despite estate bills. And basically, you gift the premium annually to the ILIT, which gives you a gifting opportunity and reduces your estate for your taxes. Okay, I'm going to have to skip to the end, and I'm going to do the questions. Now, maybe you've got one that is personal to you, and you don't want to put it out here on the internet for anybody in the world to read. And I totally respect that. So what I want to offer you guys for being here today, and there are a bunch of you, and I appreciate you spending this time with us. I consider time our most valuable asset, especially the older I get. We'll waive the consultation fee for you or anyone you refer, and as a thank you for your spending this time with us. So come talk to us, tell us about your specific needs, and we will just spend that time with you gratis, and see whether there's help you need from us. And if you don't need help from us, we're going to refer you to somebody that's a better fit. But of course, it's my hope, it's one of my quests, is to help every family have the appropriate planning so that your wealth remains with your family. Okay, hitting the chat button. Can Medicaid pierce an irrevocable trust? Thank you so much for this question. Medicaid does have a 5-year look-back provision, so the short answer is yes, but the real answer is it depends. And I love it that you asked this, and I did not plant Stephen in the audience today. Next month, I have a special guest on our webinar who is a specialist in Medicaid. So please tune in again for that webinar for more particular aspects of Medicaid planning. Not something that our practice is focused on, but it's important to a lot of people. And I particularly want to be able to educate you on that. So don't know the date sitting here today. You know what? I might know the date if you don't mind me fumbling through some papers while I'm looking it up. But, we always do them on a Thursday morning at 9 a.m. And the one in September, he says, stalling for time. Is not readily available on my piece of paper. Let me see. Hang on. September. Okay, I'm wrong. But I'm about to do an event with a Medicaid specialist, probably in September, might be live, might be a webinar. You've attended this event. We will make sure that you get an email flyer to let you know when that is. Too much to keep up with for my brain. Let's see. And thank you, Adam. To everyone, if you put personal residence in a revocable trust to avoid probate, is it still an exempt asset for Medicaid eligibility? No. I believe it to be that Medicaid can look to your primary residence for recovery. However, I'm going to defer that to the expert that I'm going to be having the event with. And we'll make sure and let all of you know when that event is. And I don't mind saying it, some things are outside my area of expertise, and Medicaid is not an area that I have focused on in my practice. I'm looking forward to learning from the expert as much as I hope that you are as well. Phew, that was a lot in, well, sorry guys, just over 30 minutes. I try to keep these to 30 minutes. I hope it was informative for you. Again, my offer to you in gratitude for your spending the time with us this morning is just write that questions at or call 904-241-1113. Questions at rocksolidlaw.com. We'll be happy to get you booked in to talk to me or Victoria Duke, our other attorney, to talk about what's best to set up, to set that up for you. And Stephen, great question. A Miller Trust is not named after me, but that is also a trust that is going to be Medicaid protection. And we will definitely cover that in the Medicaid session. So I think, sir, you need to be sure and sign up for that one because that is an area of interest to you. So I think that'll speak to you. At that event or Zoom, I will introduce you to an expert here in town to whom I refer those kind of cases. So guys, thank you so much, everybody, for spending this time with us this morning with me. It's really a joy to be able to share knowledge about revocable and irrevocable trust with you. Glad to help if we can in the future. Please do keep us in mind for the other people that you know who could use this kind of help. We would really like to help them too. We call our services Beach Professional. We want to give you very professional services in a casual beach atmosphere. You guys are the best. We appreciate you. On behalf of everybody here at Rock Solid Law and Title, I am John Miller, owner and senior attorney. Thanks. And I'm going to turn back on the Commodores to play Zoom. Hope you have a wonderful day.